بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وبارك على أشرف الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه وسلم أما بعد Alhamdulillah, we have reached our next part in the lesson in the book explanation of ʿUmdatul Fiqh, which is the bab al-uyub التي يفسخ بها النكاح. So the chapter pertaining to what essentially nullifies the nikah, so the nikah contract. So there's different aspects that will nullify the nikah contract. Allah Ta'ala knows best. So the author begins, raḥimahullāh, by mentioning متى وجد أحد الزوجين الآخر مملوك أو كان مجنونا أو أبرص أو مجذوما أو وجد الرجل رتقا أو وجدته مجبوبا. And so here the author raḥimahullah lists some examples as to if someone has a characteristic such as this, one of the zawjain, one of the spouses has a characteristic such as these, then this is a means of nullifying that marriage contract. And so he begins by mentioning that if one of the spouses discovers that the other is mamluk, the other is owned, and referring to the fact that they discover that the other spouse is a slave. So if one discovers the other one is a slave, then this is something which it nullifies that contract. Or that one discovers that the other one is majnoon, referring to za'il al-aql. So the individual is bereft or devoid of sound intellect. And so with this particular aib, with this deficiency, it now means that it's permissible for the person to nullify that marriage contract. So discover that the person is majnoon. Thereafter, Ibn Qudāmah mentions two things together. He mentions majzūman or abras. Majzūm referring to the marad, which is referred to as leprosy in English. Abras, where essentially the person's skin is devoid of melanin or pigmentation. They call it vitiligo, for example. And so here the author, raḥimahullah, mentions these two skin ailments together. Why do you think he mentions these two things? Why? You wouldn't know till after the marriage? But why is he of the opinion that this is something that nullifies the marital contract? Why is he of the opinion that it nullifies the marital contract? What would it be based upon? It's been concealed? No, that's one thing you could say. Do you know what I usually say? I ask a question and I say, don't think too hard. This one, think a bit harder, inshallah. And there's a reason, there's a deeper reason. Why he mentioned it? No problem. So he mentions the leprosy and the vitiligo. So the skin ailments, And he mentions that the presence of the skin ailment from one or two of the zawjayn is a reason for the nullification of that contract. So why is that? Why does he hold that to be the case? No. So because he is of the view that these particular ailments are contagious. He's of the mawqif that these particular a movement that there's contagion. And as a result of that, he's of the view that this particular ailment, whether it be leprosy or other than that, is an ailment which is contagious. Naam. And so now, if, for example, a person has an ailment that essentially alters someone's appearance, and he's of the view that it's contagious, then of course this is something that should be disclosed before marriage. Now, this is something that should be disclosed before marriage, and this is why he mentions this particular point. Is that clear, Barakallahu Feekum? Now, thereafter, Ibn Qudāmah goes on to mention, وَوَجَدَهَا الرَّجُلُ رَتْقًا. And so, here he refers to a ratqa, and this is the man, he discovers that the wife, she has an ailment in the private area where it is not possible to consummate a marriage. Now, so it's not possible for the man to enter due to the fact that this ailment this woman has prevents that from happening. ḥafiظahullāh. And so due to that, of course, this is something where the contract is permitted to be nullified. The opposite also is true in relation to the man that is anīn, and we'll mention that in more detail. The one that is impotent, essentially. Why is it permissible to nullify the contract in these two scenarios? Why? No. You can't fulfill the right. This now prevents the person from fulfilling the rights or the rights of marriage. And essentially as well, is a mani', it's a preventative cause or matter in attaining the goals of marriage. So from the goals of marriage, of course, is that the person, the zawjayn, they protect their private parts. And it's a means of protection from haram, from zina, and anything that leads to it. However, now, if one or both of the spouses have this particular ailment, then it prevents the person from fulfilling that particular goal of marriage. Now, is that clear, Barakallahu Feekum? So in this case, they have the ability to make fasq al-nikah. Ibn Qudāmah goes on to mention, إِن لَمْ يَكُنْ عَلِمَ ذَلِكَ قَبْلَ الْعَقْدِ. If he did not know that before the contract was made. So if he did not know all of these things, or what is this a particular characteristic as we mentioned earlier, and then he enters into the contract, and then he discovers something from these things, then he is permitted to nullify the contract immediately. He's permitted to have that contract nullified immediately. So, for example, the man, he marries the woman, and he discovers that she is majnoon. So she has a genuine mental illness, for example, that removes her intellect, and she's not of sound mind, then his person is permitted to nullify the contract. Likewise, the opposite. If it's made apparent that this person, this man, does not have sound intellect, then it's permissible to nullify the contract in that regard as well. So, however, Ibn Qudāmah mentions the qaid, he mentions that this is restricted to ilm. It's restricted to them having knowledge of that. So they have to have knowledge of these things, or not have knowledge of them, rather, if you want to nullify the contract. However, if the person dakhal al-Basīra, now so he enters into that contract al-Basīra, he has knowledge of this. ويعلم وهو يعلم بوجود هذا العيب, and he has knowledge of this deficiency. فلا خيار له, then such an individual does not have the choice in that matter. So in that scenario, for example, he's aware that the man is aware, or the woman is aware that the spouse has this particular skin ailment. That's sabīl mithal. And then, as a result of that, or he marries her anyway. That's the point. He marries her anyway, or she marries him anyway, whilst knowing that they have this ailment. After marriage, they realize the extent of the ailment, and they say, for example, لا تحمل, I can't cope with the extent of this particular sickness, and I want to nullify the contract. Are they permitted to do so? No, they're not, because they knew. Essentially, they knew. Even if they argued, for example, they didn't know the extent. This now has entered into a discussion which is subjective, whether they consider it to be excessive or not. Does that make sense? It's subjective. Someone could say they consider this ailment to be subjective, or another person consider it to not to be extensive. Sorry, or a person consider it not to be extensive. As long as they knew that the presence of this ailment was there, or this presence of the deficiency was there, then they are regarded as being an individual has knowledge of it, and so they're not permitted now to end that contract. They're not permitted to end that contract. Just like, for example, if a man was to marry the woman and he's aware that when it comes to her state of mind, that to some degree her state of mind is not one which is in the best of health, let's say. So she can be from those that lose her intellect or lose her sound mind on a regular basis. And he's made aware of this. But then he marries the woman, and then he discovers either the difficulty in living in that circumstance. And he may argue that I didn't realize it would be this difficult. That's a really mithal. This does not now permit him to nullify that contract. Why? Because he entered into that contract with knowledge. Allah Ta'ala knows best. Then the author goes on to mention, ولا يجوز الفسخ إلا بحكم الحاكم الحاكم. And it's not permissible to nullify that contract except with the judgment from the hakim, a judge, a ruler. And so, if now, for example, that deficiency becomes apparent in one of the two spouses, then it's not permissible that the person nullifies that contract except with a judge. So they have to raise the matter with the judge. Now they have to raise the matter with the judge. And this is because there may be a mas'ala within it that is khilaf. There's khilaf in that regard. There's different. And so, in that regard, the judge makes the ruling in that particular issue. Thereafter, after that point, the author goes on to mention, raḥimahullāh, when ادعت المرأة أن زوجها عنين لا يصل إليها فاعترف أنه لم يصبها أجل سنة منذ ترافعه. نعم منذ ترافعه. And so, if now, for example, if now the woman claims that her husband is impotent, and so essentially this is referring to the one that the man is not able to have the relations with the wife due to the fact that he is impotent and he does not have that shahwa, that desire, and this affects him physically as well. If this is the case and he's not able to fulfill those marital rights, then the case is adjourned for a period of a year. The case is adjourned for a period of a year. Why do you think that is? Barakallahu feekum? Is it clear, the question? No? Why does he postpone it for a period of a year before making any judgment? To see if it improves? Naam, sahih. Based upon what though? She became pregnant? Not necessarily that, no. That will enter into discussion regarding the iddah period. If he grows to have the desire, no. But what do you think they're basing it upon? Determine if it's long term, naam. Something else as well. What would he base it upon? That waiting. Why would he say, "Oh, we're going to wait for this amount of time"? Yeah, it is. You lose something? Oh, no. Basically, the Shaykh Fawzān, hafidhahullāh, he mentions that the reason for this particular hukum is due to the fact that a person's shahwa may differ based upon the fusul al-sana, based upon the seasons of the year. And so a person may have a higher level of shahwa, desire, in a particular time of the year, and that desire is less at another part of the year. So it could be now, the scenario could be that the complaint of the wife comes at a time of the year where the man's shahwa is lower. Now, for example, winter. The man's desire is lower. And she has this complaint, she raises it to the judge. So now the affair is with the judge. However, that shahwa increases in fusul where the weather is hotter. For example, once the rabi' begins the spring, and then bitali sayf, just the summer. And so this can be a factor in understanding why that is the case. And so if, however, with the changing of these seasons, the individual's shahwa, his desire, lam tataharrak, it doesn't move, it doesn't change. So you go through each of those stages of the year, and the desire doesn't change. Then we know now that this person is thabit, that the person now is impotent. So it's affirmed that this person suffers from this particular ailment. Now, and so now, if after that year elapses and it's now established that the man is impotent, then the woman has the choice. She has the choice to whether to remain with that husband or to seek separation. I would say separation, annulment of the marriage, nullifying that marriage. And so thereafter, the author mentions فإن اخترت الفراق فرق الحاكم بينهما إلا أن تكون قد علمت أنته قبل نكاحها. And so, if she makes that choice for separation, then with that choice, the judge establishes the separation between the two spouses. She made that choice. She has that choice now. And she has that choice except for if she has the knowledge of the man's impotence before the marriage. So before the contract. So again, the main point is the knowledge of that spouse. In this case, we're referring to the knowledge of the man, or the woman, knowledge of the woman regarding what the man is afflicted with, the impotence. Does that make sense, barakallahu fikum? So if now she has knowledge, she knows that this man is impotent. Now he lacks shahwa, but she marries him anyway. She cannot now take that particular complaint to the judge, seeking for that marriage to be annulled. Now I'm nullified. Why? Because she knew about it before. She knew about that particular deficiency before. So she does not have that particular choice. Why? Because she entered into the contract al-Bassām. She entered into that contract upon knowledge, knowing. Likewise, she does not have the choice if she states that she is content with the man's impotence. So she states she's content with it. If thus she states she's content with it, then with that, her choice in order to remain with him or to be separated from him is removed. No. So now if she stated that she is now I'm content, then that particular choice has been removed with that. Now, thereafter, it goes on to mention if now she knew about it after the act, after that contract, however she remains silent about it, then that choice is not removed from her. She's able to make that choice at any particular time. So this is the opposite. So if she just remains silent, then she still has the choice to seek that judgment from the judge. Now, and what is that judgment? Or what will the judgment be, essentially? Generally? Straight away? Wait for a year. Now. So this is the scenario. So the first is where the woman, she doesn't know at all. Doesn't know. And then she discovers it in the marriage. She goes to the judge, makes a complaint to the judge, and the judge mentions what? To wait for the year. After that, after the years elapsed, then what is the case? If, for example, nothing's changed, she has the choice. She has the choice whether to remain with her husband or to separate. If now she knew before, and then she goes to the judge and complains after the nikah, then what? No, there's no choice because she had knowledge of it. If now she didn't know before, she discovers it after marriage, and then she states that she's content with it, then what? Then the choice is removed by way of her stating that she's content with that. If now, the last scenario is that she marries, she discovers it afterwards, now but she remains silent about it. She doesn't make a complaint, she remains silent about it. Then what? She can make that talab afterwards, that request afterwards. Because she remains silent. Allah Ta'ala knows best. So now then after, Ibn Qudāmah mentions as well, وإن أصابها مرة لم يكن عنينا. And if now the man was to have relations with the wife on one occasion, لم يكن عنينا, then the person is not regarded as being impotent. So he does not now enter into that ruling of the one that's impotent. Why? Because the marital relations nullifies the definition of impotence. The relationship nullifies the definition of impotence. So the person now will not be regarded as being the one that's impotent. Now, thereafter, the same mas'ala mentions if the one was now if he claims, so the man claims that he had relations with the wife. The man claims he has relations with his wife. However, she makes inkar of that. So she denies that. So she denies that. Then it's a matter, as Ibn Qudāmah mentioned, it's a matter where there is the nisa, the thiqat, those that are trustworthy from the nisa, from the women. They go to her and they check whether this is the case. They check whether this is the case, whether this occurred. And if she's thayyib, so she's already been married before, and this discussion occurs, or this dispute occurs, then with that, the claim is upon her in that regard. So there has to be proof against what is stated, essentially. And so this is in regards to there's a dispute with that. If there's a dispute regarding whether the man had relations with the wife or not. Of course, if the man has relations with the wife, then all of these ahkam in relation to impotence are not valid. However, if he hasn't, then these ahkam are still valid and she can still make that particular request. Thereafter, Ibn Qudāmah mentions the ahkam in relation to the zawj, or again entering into the discussion regarding the abd, the slave. He mentions in relation to the slave, if the woman has been freed and her husband is a slave, then she has the choice either to remain with him or to separate from him. So this is in a scenario where both of them were slaves, both of them were enslaved, owned. Then the woman is freed. Then she has the choice whether to remain with that husband or to separate from him. And then Ibn Qudāmah goes on to mention وَلَهَا فَرَاقُهُ مِنْ غَيْرِ الْحُكْمِ الْحَاكِمِ. And she is permitted to separate from him without the ruling of that hakim, without the ruling of the judge in of itself. And if he is freed, so if he is freed قبل اختيارها, or he has marital relations with her, بطل خيارها, then her choice is removed. So the scenario being, there's a man and a woman. The man remains a slave. The woman's freed. In this scenario, the woman is allowed to choose. Does she remain with her husband or does she nullify that marriage? She is permitted to nullify the marriage without going to a hakim. All the other examples we mentioned, they have to go to a hakim, to a judge. This case doesn't have to go to the judge. However, if now, while she's in the process of making that choice, he's freed, then the choice no longer exists. The choice no longer exists. If she's within that same process of making a choice and then they have marital relations, then again, she does not have that choice. So, and so this is in regards to this particular mas'ala here regarding the slavery and the fasq and nikah. With that, inshallah, we'll conclude what I wanted to mention today from the points. Wallahu a'lam. And inshallah, we'll go on to the next chapter, which is regarding the sadaq, the marital dowry, and the rulings regarding that. Wallahu ta'ala a'lam. Jazakumullah khaira. وبارك الله فيكم وصلى الله وبارك على نبينا محمد وعلى آله وصحبه وسلم. نعم. Between nullifying and giving a talaq. The talaq, there are specific ahkam in relation to it. So the talaq, for example, you have the iddah, the 3-month iddah. There's nothing returned in terms of the mahr. So the woman doesn't return the mahr, for example. And it's essentially you have recognized that the marriage itself was not a valid marriage, and so you've ended it upon that. But it has to be done by a judge. It has to be done by a judge as well in most of the cases. Talaq obviously can be done by the statement of the husband, and then that'll suffice. With this is done by way of a specific talab, a specific request being made, and then that will nullify the contract. So, for example, you find maybe the woman, she may seek to nullify her contract with the husband, and she will, rather than seek the route of the khula', because with the khula', of course, she has to pay back the mahr, in most cases. Rather seek that route, she tries to take this route, which is to nullify the contract in totality, which would mean that there's nothing for her to pay in response to that. No. The contract's nullified, she don't return it. No, so this is the it goes back to what the judge, we based on what the judge orders essentially. So the judge can order that she pays it back. Now, or he can state, because an example would be, we're talking about who's at fault as well. So if it's stated, for example, that the contract should be nullified and it's the fault of the husband, then generally speaking, they wouldn't make a judgment for the mahr to be returned. And this is why you find that a lot of the time this is what is sought from the woman, because she's seeking to kind of remove the burden of paying the mahr as well as establish that this person is upon fault, so that it doesn't have to be paid. And to remove herself from the marriage as well. Allahu A'lam, I need to double check the specifics regarding that. But I will mention it inshallah next week. If you text me around, inshallah. Jazakallah khair. Barakallahu feekum.
Shaykh, you mentioned if the woman already knows that a man's impotent, she chooses to still marry him.
Yeah.
Then after she claims that she feels like immorality.
She fears immorality.
Yeah,
yes.
upon herself.
Yes.
Can she then choose to separate?
She can still separate. There's still means to separate, but the fasq al-aqd, yani annulling the marriage is not possible. So she still can seek, for example, the khula, but she cannot seek now to annul the marriage for that reason, because she was aware of that reason before she entered into that contract. So if she does fear for herself, for example, or fear that she's not going to be able to give the rights, then she can do that, inshallah. Barakallahu feekum. Allah khair. Wallah. Sallallahu wa barak ala nabiyyina Muhammad wa ala alihi wa sallam.